Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped planned communities and condominium associations throughout the state of Arizona.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content of these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.
Welcome to the podcast. Here's Beth Mulcahy.
Good morning, everybody. Welcome to our August 1st Fridays. Can't believe it's already August 1st. All of you are starting to join. I'm just going to do some introductory remarks, and then we'll get right into the questions. So welcome, everybody, to our August 1st Friday event. My name is Beth Mulcahy, and I'm the founder and senior partner for the Mulcahy Law Firm in Phoenix, Arizona. Our firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. And I also currently serve on my HOA board and have for many years. Here's how First Fridays is going to work today. If you haven't already done so, please submit your First Friday questions in the Q&A box on Zoom or in the comment section on Facebook Live as soon as possible. And then I will answer all the questions between now and about 10 or 10:30. Just a quick friendly reminder, due to the large volume of questions we receive during First Fridays, this is a free opportunity and it's limited to one question per association. If you plan on submitting a question live during this session, please include the name of your HOA or condo and your current role, such as board member, homeowner, manager, when you submit your question. Thank you for understanding. Okay, let's talk briefly about the Arizona legislature. For those of you who may be following some of our classes in the past, you may be aware that the legislature closed in their legislative session at the end of June. And there were several new bills that were signed into law by our governor that pertain to associations. We're going to do a quick little summary here on what those laws are. We're going to be spending more time on our September First Friday event because that will be right before the laws are going to be going into effect. A couple things, the starting points on that. Again, there were 4 bills that were passed into law this year. These 4 new laws are going to go into effect or become effective on September 26, 2025. So we're going to have a couple more opportunities to talk about how these bills may impact our industry. Let's see. Let's just get into the 4 bills quickly so that you are aware of them. And again, we're going to be doing more in-depth analysis on this when we get to our September classes. The first bill is Senate Bill 1039, and this is a bill that deals with recording of board meetings. And this bill requires that if a board records a meeting that is open to members, so a non-executive session meeting, just like a regular open board meeting, the board is required to keep a copy of the recording for at least 6 months and make the unedited recording available to any member on request. And so I don't think this is going to change really too much how people are doing business. If you're having Zoom meetings, which super majority of our clients are right now for their board meetings, and it's an open board meeting and you're recording it, which there's a free feature to record it on Zoom. Basically, all you need to do is just keep a copy of that recording for at least 6 months. And then if any member wants to see it, you have to give them an unedited version of that recording. If you don't record your meetings, then obviously you don't have to under this law. But if you do record them, you do have to keep them for 6 months and provide a copy if an owner wants it. Okay, the next bill deals with political signs. It's Senate Bill 1378. And this bill expanded the definition of a political sign to include a flag. So political flags also now can be flown consistent with the prior law regarding political signs and when the signs can go up and when they need to be taken down after the election. And again, we'll talk more about that, but I think that's just kind of like what I would call a sign of the times bill. Really with the federal presidential elections, we started to see more flags for the candidates. And it was kind of a question mark. Hey, is this a political sign because it's a flag? Does the flag law apply or does political sign law apply? And I think the legislature reacted by telling us that you can have a political sign that's a flag, but you still have to comply with all the requirements of the political sign laws for planned communities and condominiums. Okay, the next bill is Senate Bill 1494, and this bill it applies only to planned communities, just so you know, this next bill. And again, it's Senate Bill 1490. And basically what it does is we can't foreclose on an assessment lien until the delinquency is 18 months delinquent. It used to be 1 year. and the dollar amount from $1,200 to $10,000. So a little bit different situation now for planned communities starting on September 26th. We won't be able to foreclose until the assessment's 18 months past due or $10,000 is owed in assessments only. Let's see, House Bill 2322, this one applies only to condominiums and it's going to have a very limited scope. This deals with commercial structures, and this bill addresses assessments on commercial structures versus residential structures in a condominium. There also are broader definitions of what exactly is a commercial structure and further definitions of common expenses and what exactly is a residential structure. So those are our 4 bills that will go into effect at the end of September. And again, we'll be talking about those more when we get into September, where our class is in September. Okay, let's get right to our questions this morning. Looks like I'm just going to do a quick number of questions that we have. Just check real quickly. It looks like we have about 40 questions right now. But I see that questions are being added as we go. So let's get started on our questions. Our first question is from an owner, and it says, my management company filed a lien on my unit for unpaid monthly fees that I contested due to them not doing repairs. I paid those fees in January and am disputing the administrative fees and the late charge. The management company has charged me $35 for notices and continues to charge me late fees monthly while I dispute these fees. Can they charge monthly late charges on this disputed balance? So this question actually raises a lot of really good questions. So just as a starting point, it doesn't say here whether you're a condominium or a planned community, but basically my interpretation of this is, okay, so under Arizona law, whether you're a planned community or a condo, associations can charge a late charge if the assessment is past due. It's a little bit different analysis for each one, but they do have the right to charge a late charge. They also have a right to charge administrative fees for any administrative fees that are incurred in collecting the assessments that are unpaid in a time and that are not paid in a timely manner. So both of those charges are valid. And unfortunately, you probably won't want to hear this, but I'm going to tell you anyways, even if you're disputing something that's happening in your association, like you haven't painted my house or you haven't done the repair that you're required to do under our CC&Rs, you never should withhold paying assessments. That is not a valid defense. You should just pay your assessments under protest or send a letter saying you're paying them, but you're protesting because these things haven't been accomplished by the association and you're required to do so. Okay, now let's look at the question at issue. You're saying that this $35 per notice is on your ledger right now, and they're also charging you a late fee while you dispute these $35 administrative fees. And so I don't know what your payment history has been on your assessments, but the association can only charge a late fee if your assessment payment is late. So they obviously had the right to charge it on the month that you didn't pay in January that you didn't pay because it wasn't paid in a timely manner. But can they continue to charge you a late fee just because you have that $35 balance? I'd really need to see your ledger to see when you're paying your assessment, and also to find out, like, when you pay your assessment now each month, are you indicating that it's for this month or are they applying it to the past due, amounts? So I don't quite know the answer on that, but if you're paying it through like a lockbox, it should indicate that you're paying it for the month at hand. And if you're paying it on time, they shouldn't be charging you a late fee. So I hope that answers your question. Again, I'd have to look at the ledger and find out from you how you made your assessment payments and if you indicated which month it was for when you were making it for every month from February to current. Okay, next question from a board member. May the HOA shut off water for non-payment of assessments, which includes water, sewage, and garbage? This is the second year of no payment, except for collections last year, 40% recovery, or is foreclosure a better way to deal with this? Okay, I'm not a big fan of terminating water services to a unit because A, it's inhumane, and B, it could raise other liabilities for the association, especially with the heat that we have in Arizona. If somebody's not able to have water to their unit or lot, that could be problematic in terms of their health. But that being said, from a legal perspective, if you want to suspend water services, a couple things need to be in place. Number one, the association has to be in charge of the water, right? I mean, they have to be paying the water bill. And you have to check with the plumber to see if actually it can be done, because sometimes you can only turn off if it's a multiplex unit and there's maybe 4 units in a building. There may not be a shutoff valve for just one unit. You may have to shut off the water to all 4 units. So is it feasible is important. The third step, which is the most important thing, is it in the CC&Rs that you have the right to do this? You have to have this in the CC&Rs in order for you to be able to do this. And then obviously you should be providing notice to the owner before you take this step. Now, again, I don't suggest this because I do think it's inhumane and it creates liabilities for the association, which concern me as a lawyer that works in this industry. What I would suggest is if you have an owner that hasn't paid for a year, it looks like maybe a little more than a year, and you are trying to decide what's the best way to collect the money, really the best thing to do would be to have our firm do a credit evaluation on them and determine, what does their credit look like? Is their credit decent? Do they have other judgments against them? Do they have high credit card balances? Do they, what's the debt to credit ratio on the property? Are they underwater? Do they have equity? And then we can come back, we call this like a credit snapshot. Then we can come back and provide that information to you and give you recommendations as to if they're employed, maybe it's better to get a justice court judgment against them. Or if they have a lot of equity, maybe we suggest that we do proceed with foreclosure. But one thing I'm going to mention is you probably want to get on this right away because that new law is going into effect September 26th, and it's going to make it more difficult for planned communities to foreclose. So I think I would, and it's also already been 1.5 years probably that they haven't paid. So I think you should put this to the forefront and really get on this month and do this evaluation so you can determine what's the best way to collect on this debt. Okay, question number 3 from an owner. Is the property management company and/or the board required to provide the executive session agenda to the homeowners? And what's the statute on email correspondence and voting between board members in general? Okay, the Arizona Open Meeting Law statute for planned communities is ARS 33-1804, and for condominiums, it's ARS 33-1248. And so here's the situation on the executive session. The board is required to notice executive session meetings at least 48 hours in advance of the meeting. And if it's an emergency, that notice could be suspended, but it has to be a true emergency. The association also is required to provide which sections under 32 or 33-1248, which executive session topics they're going to be discussing in that meeting in the notice. And I also would suggest that the board provide an agenda as well. It's kind of unclear under the new statute. So last year there was a law that was passed that said that boards must provide an agenda to members prior to the meeting with the notice is what we suggest. It doesn't specifically call out the executive session, but I think it is a good thing to do. Just make the notice the agenda. And you don't have to put any specific detail, like we're going to be talking about Johnny Appleseed's delinquency. You can just put discussion of delinquencies. And then, of course, the statute number and which section of the statute number you're going to be using in that executive session. Let's see. And then what is the statute on email correspondence and voting between board members in general? Really, it's open meeting law. Like any decisions that are made by the board need to be done in an open board meeting. Really, the only exception to that would be in emergency circumstances. A board may be able to take action quickly if emergency circumstances dictate that they take action. Okay, next question. Number 4. When your association documents only refer to fees as monthly, can the board decide to make them semi-annual? It's really hard for me to answer that question because I don't specifically know what your documents state on this. And so what I would do is what I would recommend that you do is have your attorney look at the documents to see if it's possible. What they could do is still give owners the opportunity. If it says it has to be monthly, what they could do is still let the owners that want to pay monthly, but then allow the other owners to pay semi-annually if they want to. They would just be paying in advance. And so there wouldn't be any late fee implications. Okay, next question, number 5. We had to condense this question. It's from a board member. What are the legal requirements under Arizona law for signing a recall petition? Some petitions that I have seen have just a place for a printed name, signature, and lot number. Is there a place where I can print off an official form that shows the legal requirements and or a state statute calling out the legal requirements for filling out petitions? Okay, so yes, we have a cheat sheet on the board removal process that we're going to be sharing with you. Also, the statutory requirements for a board removal petition and the entire board removal process can be found for planned communities at ARS 33-1813 and for condominiums at ARS 33-1243. So what exactly has to be on the petition? So each page of the petition should contain a statement that says, like, I am requesting that we have a recall meeting to recall the following board members. And then it should have the person's name printed so we can read it, their address, either their address or their lot number, and then also their signature. And it would be nice if we also had date, but it's not required to have the date. So I would suggest you take a look at our cheat sheet and the statutes on this. Our cheat sheet is especially helpful. We make it really easy to understand if you want to look at the entire process. Okay, next question, number 6 from a board member. ARS 33-1804 states that any portion of a meeting may be closed only if that closed portion of the meeting is limited to consideration of one or more of the following. So these are like the executive session topics. The statute then lists 5 exceptions. My argument is that consideration means discussion, but not taking formal action in executive session. I feel that the board can discuss sensitive matters confidentially, but then bring any actionable items where a vote is required to an open meeting where members have the opportunity to speak. I believe this can be done at an open meeting and still maintain confidentiality. What is your stance on this? I would say that no board handles it that way that I'm aware of. Most boards discuss and take a vote in executive session on executive session topics. The statute does, it's permissive. So it says that you don't have to go into executive session. So if a majority of your board wants to handle it this way, you certainly can, but you're going to have to remember that you don't want to create liability issues for the association by discussing names and lot numbers regarding delinquencies. So I would really caution you and advise against doing what you're proposing. Okay, question number 7 from an owner. Is an HOA required to disclose in written board procedures or guidelines or other documents published for respective community to read and understand the collection procedures and what properties are in foreclosure in the association? So the association, I'm not really sure what you mean by board procedures or guidelines, but so if the board has a policy like a collection policy, I think that's probably what you mean. If they have a collection policy, do they have to give it to the owners? And I would say, well, it's typically collection policy is going to be approved in a board meeting, and that will be reflected in the minutes. And the policy should be attached to the minutes when it's approved. I think, of course, if your goal is to get people to pay assessments, best practices would be to also publish that or put it in a newsletter or put on your website for the association so that owners are aware that there is a policy on this and these are the implications if you don't pay in a timely manner. And so it's not required to publish that, but I think it's best practices. Obviously, if you pass something like this, it should be done in an open meeting and there should be minutes reflecting it. Let's see. I think there's a second part of this question. Let's see. Publish and understand. Okay, do we also have to what properties are in foreclosure in the HOA? Do we have to publish that? No, you should not be publishing that. It is public record if anybody wants to look it up, but the board should not be publishing anything about any lawsuit, litigation, foreclosures that it is involved in. Okay, next question, number 8. Is it appropriate for an HOA president to identify a homeowner by name at a meeting, mention their document request, suggest that dues might rise because of the related expense, and then ask the homeowner to comment? Also, is it proper for the meeting minutes to note this without including the homeowner's response? Well, this is kind of a loaded question. I would say it's unusual to handle something like this, but if the homeowner is making repeated requests that are affecting the budget, then I think it is fair game to mention that there have been some requests. I think it's probably not in the best taste to list the person's name and ask for the person to comment on it. But when discussing the budget, if it is financially impacting the budget, I think it is something that you could say, hey, we're having higher legal fees or higher costs because the management team is having to put together these really large records requests. Okay, next question. Number 9. Where do you draw the line on indemnity clause for work that's done in the community? Does it fall in line with the amount of money being spent for a particular project or for all vendors that perform work on the property? For example, roof repairs in a common area, tree trimming, pool work. Should this be a standard procedure for all services? So I think probably what you're referring here, if I'm reading this correctly, is like you're hiring a vendor, you're signing a contract with the vendor, and then there's like an indemnity clause in the contract. And you're wondering how this should be structured. Typically what happens is the contractor has a contract that they send over to the association to sign and review and sign. And so when we're looking at that indemnity clause, we just want to make sure that it's fair. That is the most important thing, is that it is fair to the association, fair to the vendor as well. And so where do I draw the line on it? Typically if you were having a contract that's in writing for services that are being provided, that would be where we would typically see the indemnity clause. And we do typically look very carefully at that language. And there are oftentimes changes requested before we'll sign the contract. Remember, if you're ever signing a contract with a vendor, you do want to get legal counsel to take a look at it to make sure that the contract isn't one-sided or will have negative impact or implications on the association. Okay, let's see. Next question is number 10. Should a board use resolutions or consent to action to adopt a fine policy and appeal process or accelerated short-term rental fines? I really think that this should be done in an open board meeting, and just the minutes should reflect what is decided. If you have a special policy on it, you can attach the policy to the minutes. And again, kind of like the other question we had, you may want to publicize that to the community, put it on your webpage so people are aware of it and they know the consequences. So there really isn't a hard and fast rule, like should they use a resolution, should they use a consent to action? But the hard and fast rule, in my opinion, is this should be done in an open board meeting. Okay, next question, number 11. We condensed this question because it was a little bit long from an owner. Our board is considering an owner survey about allowing RV parking inside yards, though our CC&Rs currently prohibit it. They say it is to gauge community interest before formally voting on a change. There are already RV garage home options in the community. I'm concerned this could impact my home's value. Can the board send out this survey? So answer on that would be yes. They certainly have the right to do that. And pursue a CC&R change, even if it could reduce property values. Now, they can always do a survey. The question, kind of the loaded question here is, can they change this section? There are several cases that have been cited in the past 5 years by Arizona courts that might make it really difficult for the board to actually do this amendment. So, of course, they can do a survey on this just to see what the interest is in the community, but they need to be careful and get legal advice before they actually make this change, because there could be an argument that this proposed amendment, if it passes, isn't reasonable and it was not foreseeable. And a homeowner could challenge it under a recent case that was passed under Arizona law based upon that provision, saying that, hey, I bought in here because I didn't want to have RVs parked in the lot. I knew that they were going to be parked in the RV storage unit where they're not visible, and now they're trying to change this, and it wasn't foreseeable to me that they were going to do this. I think there's an argument that could be made on that. So they may not even be able to do the amendment. Okay, next question, number 12. This one is from a manager. So great to have a few managers on here today asking questions. We want to comply with Senate Bill 1039 and use Zoom's AI tool to generate meeting transcripts for our open board meetings, which are held in person and on Zoom. Since AI transcripts aren't always fully accurate or may not clearly show who made motions or actions taken, are we allowed to revise the transcript after the meeting to clarify who did what, correct any errors, and highlight any official board actions? A couple things. First, we are working right now on a cheat sheet for use of AI community associations. So on that, this is definitely becoming a hot topic in our industry. And we are pivoting and getting a new cheat sheet on that, which we hope to have finished before the end of the summer. So my experience with Zoom and the transcripts that are prepared by Zoom is that they are very accurate. So I'm surprised to find that they're not accurate. Maybe they misspell my last name, right? Or something like that. Those type of changes, yes. But you couldn't change anything that was actually decided in the meeting. You couldn't change it, from what actually happened, I think is probably the best way to say it. So changes to correct any typographical errors, or if they missed something because the microphone wasn't going well or they couldn't hear well, that's an option. But my experience has been that the AI is very good on these transcripts. And I have looked at hundreds of them now of meetings because a lot of our clients are asking us to review the transcript to get advice after the meetings. And I found them to be very accurate. But that being said, if there are typographical errors or other errors, the minutes should reflect what is the correct decision that was decided at that meeting, not the transcript. Okay, and you can make your comments on the transcript as to whatever changes you think are needed to be made. Okay, next question. Question 13 is from an owner. We condensed this question because it was very long. Our HOA board meets monthly as required, but meetings are held offsite at the management company's office at times 4 to 5 p.m. on weekdays, sometimes 10 a.m. on Thursdays, that most members cannot attend. One board member can't make it at all, and the board and manager seem to make decisions as a block, despite complaints about the scheduling. Meetings used to be at 6:30 p.m. on campus. Everything seems to comply with the bylaws, but members feel excluded. Is there anything owners can do to get meeting times or locations changed? I think you should provide feedback to the board, especially the board member who's not able to attend the meetings, that, hey, we need to have meetings, at times where everybody can attend and where it's convenient for everybody. People really are not doing in-person meetings very often anymore in associations. Just you need to be aware of that. If they offer a Zoom option, hopefully more people will be able to attend via Zoom. And they really should be, if people are saying, especially the board member who can't be there, if they're saying, hey, I can't attend this meeting, they should try to be more accommodating in terms of the timing. And maybe what they could do is have meetings every quarter. They could have one at 6:30 on a weekday by Zoom so that people would have an opportunity to attend if that's the best time for people who are working to attend. But I would say provide feedback to your board and let them know what you're thinking and ask them to please be respectful of the wishes of the membership and give us an opportunity to attend and be heard. Next question, number 14, from a board member. Our governing documents state that our CC&Rs may be amended by a vote of co-owners representing 75% of the interests in the regime. Whenever a co-owner's interest is subject to a mortgage, his affirmative vote shall be included in said required percentage only upon concurrence of his mortgage. Do we actually need the lender to respond in writing? We've read that lenders don't respond to this type of inquiry from HOAs and condos, and it's been suggested that this type of requirement of lender participation is out of date and moot. Can you confirm that we can ignore this requirement in order to revise our CC&Rs? So I cannot in good faith tell you to ignore that section. There are some strategies on how to comply with it. What I would suggest you to do is reach out to your law firm to help you with the amendment process. There's a way to first what I would do is get the 75% vote first. Okay, so make sure that you have the homeowner's vote. If you get that vote, then I would contact the units that have a mortgage or deed of trust on their property. And what we typically do is we send them a letter. We inform them of the amendment, and we let them know that unless they object within 30 days of receiving this, that it will be considered an approval by them. And we send it certified mail, return receipt requested, and tell them that their signature, whoever signs it on behalf of their mortgage company, that signature is an approval unless they tell us in writing that it's not an approval. Now, we only do that for mortgage companies because honestly, they really don't know what to do with these requests. And it's problematic if we just ignore this section, just blow off getting their votes. We could never do this type of an approach on getting homeowner votes, but in this special circumstance, because these documents were probably written in the 80s, and at that time, this was something that was commonly done. But now mortgage companies don't even know what to do with it when it comes in. So just to check the box in case somebody challenges this and we have to go in front of a judge and say, did you notify the mortgage company? We have proof that we did. This is one way to handle it. If you don't want to do that, just recognize that any owner could challenge us, the amendment, for not doing it. And of course, when you do your amendment, take out the requirement to have the mortgage company approval. Okay, next question, number 15. Arizona state law requires an annual audit, review, or compilation of the finances. For small HOAs like ours, 35 properties, it is very expensive, and we have had a hard time finding someone to do this for us. Is there help available to find a firm that we can afford, and what are our options? So yes, you can. Well, first, let's back it up and talk a little bit about what the statute says. So the statute says that in every association, whether you're planned community or condominium, you need to have an audit, review, or compilation every year. And if your bylaws require the audit to be done by a CPA, you have to use a CPA to do the audit. And so if your association, I don't know what your bylaws say, so you may not have the requirement that a CPA has to do your audit. If that's the case, then really anybody can do the audit. It could be a committee that you appoint. It could be your treasurer or your management company, although I really would advise against doing that because we don't want the fox guarding the hen house, right? We need an independent person doing this. You also could go to like a bookkeeping service and see if they would be willing to do it for you at a lower charge. If you contact our office, we can give you the names of several CPAs and bookkeeping firms. They might be able to give you a bid to see if that is financially feasible for your association. Okay, question 16 is from an owner. If an HOA board delegates all board decision-making authority and responsibility to their management company, is that a breach of fiduciary duty by the board? That is very unusual, and it really is not customary as to how things should be done, and it could be a possible breach of fiduciary duty. But I don't know enough about what they're delegating and if there's oversight by board members. Maybe they just said, like, you can spend up to $5,000 if something breaks, and that's not going to be a breach of fiduciary duty. That's just, planning ahead in case everybody's gone in the summertime and the pool pump breaks. So I need to know more about it, but delegating every single responsibility to the management company, that's not a good idea. The board needs to be in charge and the board needs to be making the decisions. The management company is just there to help the board execute on those decisions. Okay, next question, number 17. We are a board of 3. This is from a board member. One of our members refuses to vote or votes no on everything while verbally disparaging the president at every opportunity, even in front of homeowners at board meetings. Are we at any legal risk moving forward on all decisions with just 66%? Our governing documents only require 50%, but it feels risky that all board decisions are not 100%. Kind of 2 questions here. One question from you, and then I'm going to just give you a suggestion on the other one. The majority rules in a board, and that's perfectly fine. It's nice when everybody on the board can agree, but that's probably most of my associations have dissenters or people that don't agree with the action that the board's going to take. So that's pretty common. But voting no on everything, that's pretty unusual. And attacking the board president at board meetings, that's not appropriate. You might really want to consider having our firm come in and do a boot camp for your board and talk through whatever issues are going on behind the scenes with your board so that you can be more functional and more professional in your board meetings and figure out what's going on with that other board member and try to get that person on the right track. I will be honest with you, I serve on 2 boards, a master board and a sub-association board, and I have a similar situation, unfortunately, on one of the boards that I am a member of. And it is very frustrating and tiring to deal with somebody like that. And the sooner you can get help in to try to get through whatever the problems are, the better. Sometimes it's unsolvable. Like it's just like a mental illness thing. And, you just have to find good candidates to try to replace that person when that term is up. Okay, next question from a board member. 2 homeowners recently experienced break-ins in my 5,800 home community. Some homeowners are questioning why the HOA management team and board are not sharing the details of these type of incidents when they occur in our community. Since these are police matters, the HOA often only learns of these secondhand. Do HOAs have an obligation to provide this information to the community? And if so, must the HOA have the victim's permission before sharing details? So this is definitely kind of a sticky situation because you're hearing about it secondhand. You don't have firsthand knowledge. If, as a board, I don't think that you should be commenting on this without firsthand knowledge, number one. And let's say the homeowner does come to the board and say, hey, this happened. I mean, really, I wouldn't single out this particular homeowner and give the police report or anything to the homeowners. But what you could do is in your communication to the owners, just up your information and say, remind people, don't leave valuables in your car that are visible overnight in an unlocked car. Don't leave your garage door open because there has been one break-in in our community, and just make people aware of it. You also may want to consider having your local police department come to your annual meeting and talk a little bit about crime prevention. And these are all good suggestions if something like this is occurring in your community. We have a really great cheat sheet on preventing, liability for associations in the event that criminal activity occurs on association property. So I would encourage to take a look at that as an association board if this problem persists, or reach out to your legal counsel to talk about what would be some other steps that you may want to take. Obviously, if you're a gated community, make sure that you're notifying your security guards or security services that, hey, this has occurred. If you have firsthand knowledge of it, and just make them aware if they're patrolling that this is something they should be watching out for, like open garage doors. And they may want to tell people, hey, you need to close your garage door. Okay, next question. Does HOA management company need to provide an unredacted copy of a complaint upon request to the subject of complaint, including identity of person making the complaint? So board members asking, do we need to provide a copy of a complaint? I'm assuming this is from a homeowner upon request to the subject of the complaint, including identity of the person making the complaint. Okay, I think what's probably happening here is there's a violation and an owner wants to know who complained about my dog barking or who complained about my yard. And so, yes, there's specific procedure under the law that would have to be followed for us to be required to provide this information, which would be who's Mrs. Kravitz who's complaining about something. Basically, how it works under the law is if the association sends a violation letter to an owner regarding a violation on their property or violation of behavior on their property or behavior on the common areas, the association, the owner can write back and ask for certain categories of information. And when they write back, it has to be sent by certified mail. One of the categories of information that they can ask about is who complained. And if that occurs, then the board has to respond in writing to that complaint. If they don't follow that specific procedure, including sending it by certified mail, no, the board doesn't have to provide the name. But if the owner is smart, they could make a records request and ask for any complaints regarding my property from third parties, and they might be able to get it that way. Okay, next question, number 20. What is the turnaround time for a sheriff sale? It really just depends on how busy they are. But right now it's taking the sheriff between 8 and 12 weeks to notice a sheriff sale once they receive the paperwork. And then they give us a date. We have to wait for the date. And the whole process could take now 4 or 5 months to get the sheriff sale completed. Okay, next question, number 21 from a board member. We understand the accommodations we have to make for a homeowner with a service animal, but we're not sure how they extend to visitors. For example, we do not allow dogs on our grass common areas or the pool. Do we have to allow someone who's visiting to bring their dog out there? So short answer would be no. Now, if they have some sort of, it's a service animal, like they're blind or it's a true service animal, somebody's having seizures and they need to bring their dog with them to the property when they come and visit their parents or something, that will be an exception that we would have to make. But just the visitor, resident that's coming to visit on Sunday and they bring their dog, no, we don't have to allow that. And really the owner of that lot or unit is responsible for the behavior of their tenant, and you should be sending them a violation letter. Okay, next question, number 22. Please offer advice for board members to deal with an HOA president that operates like a tyrant and runs meetings like a dictator. Our president recently sent an op-ed memo to the board, basically stating that the board serves to the president, and the president must have input on all actions by the board. This president also stifles board member comments during board meetings, often interrupting conversations after 15 or 20 seconds. Okay, so honestly, the same approach should be taken as we talked about the one board member who votes no on everything and attacks the president. Same approach. I really think at this point you need to have a boot camp. And I think how I would approach it is maybe the president won't want that because they want to be in control. And so what I would recommend is a majority of the board can vote on this. So have a majority of the board make a motion to have your attorney come in and do a boot camp for your association. And you don't have to tell the president that, hey, we're doing this because of your behavior. What you could do is just say, we need to have an overview of the law. And we all want to be better informed and we want to better understand what our rules and responsibilities are as officers. And therefore, a majority of us want this. And if that happens, the president cannot stop it. And hopefully the president will attend. I'm sure he or she will, because it sounds like they like to control things. And at the meeting, prior to the meeting, if you send me an email, if I'm the person that's doing it, tell me kind of what's going on. I will tailor my approach to my presentation to address these issues and try to get everybody talking so that we can have a better relationship as an association and so that the president can better understand that this approach is not the best approach for running your association. Okay, next question. Number 23. During a board executive session, can we vote in closed session or must we only discuss and vote in an open board meeting? So we had this question a little bit earlier in the presentation. So it's my opinion the vote can be taken during the executive session on executive session topics, and it does not have to be discussed in the executive session and then voted on in the open meeting. Question number 24 from a board member. Last night, the VP of our association stopped the agenda midway and added removal of the president and replaced the entire board officers. After he was done, he also added the removal of a committee volunteer that served on the design review committee and social committee. None of this was listed on the agenda. Is this legal? Not legal? Thanks for your help. I mean, ideally, discussion of officer positions and discussion of committee members and selection of committee members should be placed on the agenda. Now, I don't know what the situation was here. Obviously, if the VP was just acting by him or herself, the rest of the board should have just stopped it and said, no, we're not voting on this. A majority of us say we don't want to vote on this, but it sounds like maybe it happened. So maybe a majority of the people did want it to happen. I'm not saying it's illegal. I'm just saying it could probably be pushed in under new business or something like that on the agenda, if you had that on your agenda. But it's unusual. But I'm not sure I can say that a judge would call it illegal. Okay, next question, number 25. Our planned community changed property management companies last year using website information, 30-year history, owner interview, and so forth. We were sold on what kind of company they used to be. We are depressingly being underserved with zero confidence or improvement. We are aware of how difficult the industry has become as our original management company went in that same direction. Are there any networking opportunities or other resources that identify with professional, local, successful management companies that are proven to still work well with the small HOA? So I think just a general comment, there has been kind of a shift in Arizona in terms of management company ownership over the past few years. And there's kind of been maybe the people that started these management companies in the 80s and the 90s, they're retiring and they're selling their management companies. And there's management companies from out of state coming in and taking over these management companies. And we've been hearing about a lot of hiccups with these transitions. But there are still, of course, many wonderful management companies that are out there. And so really what I would recommend is if your association is in the market for a new management company, I would recommend that you give me a call or email me and we can talk about it. We can talk about what your needs are, the size of your association, geographic location of your association, and come up with some 3 or 4 names that would be a good fit for you to interview. Also, make sure that you're talking with your current management company about the problems and asking them to improve, giving them specific deliverables that they're not handling well, maybe asking for a manager change so that you're not suffering through whatever time you may have left with the management company. Who knows, maybe they'll perk up and do what they're supposed to be doing and the relationship will get better. Okay, next question, number 26 from a board member. If a board member is not performing their duties, can member roles be reassigned during the one-year term with the approval of the majority of the board? So interestingly, we just kind of had that same question, right? Yes, this can be done. In most bylaws for associations, the officer positions are voted by a majority of the board. So if something's not working out with a particular officer position, you certainly can vote, a majority of the board can vote to change that up. Question 27 from a board member. Can a properly noticed meeting be adjourned to a later date without needing to deliver a second notice? This would be a continuation of the meeting, usually to gather more information or to offer a break due to the length of the meeting. There would be no change or addition to the agenda. I have to see your documents in terms of, is this like a meeting of the membership, or is this just a regular board meeting, special meeting of the membership, annual meeting? I would say, why wouldn't you give additional notice so that everybody knows when the meeting is going to be? Sometimes the documents do not require new notice. It just depends. So I would say, with the limited information I have, I would say I wouldn't do that without giving notice regarding the continuation of the meeting, but I'd have to see your documents to give you a more formal opinion. Okay, question number 28 from a board member. Our secretary does not do very well recording the minutes, misses items and records items from the previous month as if it were the current month. If we buy a recording device and then transcribe the minutes, is it acceptable to only keep the written minutes? The recorders seems to be mostly digital, and I don't know how we would keep those. I have heard of AI taking and transcribing minutes as well. So lots of good issues here. So first, maybe using AI to transcribe the meeting for your secretary would be a really good idea, because it sounds like the secretary is having trouble. Second, having Zoom recordings would be really smart, because having a meeting on Zoom, even if it's just to record it and allow members to attend if they want to, would be a really smart thing, because coming September 26th of this year, if you are recording the meeting, you need to keep it for the minimum time period that they're requiring under the statute, which I believe is 6 months, before you can get rid of it. So the law is changing on this. So you wouldn't be able to, even if you keep using your digital recorder, you'll still need to find a way to keep that recording for 6 months after September 26th. Okay, next question, number 29. I am on the board of my HOA. Can my management company charge me to look at invoices from a previous year? I don't want copies. I just want to review some vendor invoices that relate to issues happening again in our community. I was told they would charge $75 to my community if I come in and review this information. There's no specific line item in our contract with them stating they can charge for this. Okay, so good question. Sounds like you're a board member. If it's not in the contract, the management company should not be charging that to your community. They can't charge it to the homeowner under the law if a homeowner is making this request directly to the homeowner. But how it works in our industry is, if the management company is going to charge the association a certain fee, it has to be listed in the management contract. So I think you have a good argument here that they can't do that. Okay, question number 30. This is a condensed version of a question that was submitted to us from a board member. And the question is, an owner reported a hazardous tree in the common area. A board member asked the president to consult legal counsel, but the president did not act. Can a board member contact the association attorney directly, given the risk of liability if someone is injured? I mean, if you have a majority of the board agreeing to contact the attorney, then you can go ahead and do that. But I wouldn't, as one board member without the support of the board, contact the attorney. Question 31. Our association does not have a fine schedule or any rules and regs beyond the CC&Rs and the bylaws. Our CC&Rs do not specifically allow for levying of fines, only that failure to comply will be sent to the attorney for legal proceedings. Can the board create rules and regs with the fine schedule and enforce them legally without it being specifically noted in the CC&Rs? So if you're a planned community or condominium, yes, state law does allow you to fine after notice and an opportunity to be heard. So the board should consult with their legal counsel on this, but they likely do have the right to do that. Question number 32 from a board member. We recently purchased computers for board members, bare bones for email, Word, Excel, and file sharing. Can we create a policy making board members personally responsible for damage done to computers for misuse, like loading improper software and damaging the computers? I think that would be suitable if the board's paying for it, having some protocols in place so that the computers are used in a manner that would be consistent with only board member use and that they don't damage it. If they do, that there may be an expense. I think that's fine. Okay, next question is question number 33. This is a condensed version of a question. We recently updated our CC&R document and prepared a summary of the proposed changes with a disclaimer stating that the summary is not a substitute for reading the full document. Does including this disclaimer protect us from claims that a summary did not fully explain or disclose all changes? This is kind of a loaded question. So the summary is fine if you want to do that, but you should also attach a full copy of the changes so that the board or so that the homeowners can see the full changes without your summary. And I'm fine with the disclaimer that you have, but I do think you should also provide them with the full copy or give them a link where they can find it on the website or whatever. Okay, question number 34 from a board member. Recently, we had 2 outdoor parties at the clubhouse, one on the patio and another around the pool area. Alcohol was offered and consumed at both parties. A board member brought to our attention that Arizona has a law that prohibits drinking alcohol in public spaces. Could you please clarify if the outside area, patio, and pool area of an HOA clubhouse is considered a public space under the Arizona law? I'd have to know specifically which law they're talking about. I would consider a public space probably to be like a public park. And I'm assuming, I haven't seen your documents or your plat, but I'm assuming that this pool area is a private area, either owned by the members of the condominium if you're a condominium, or owned by the association if you're a planned community. So based upon the information you're telling me, I don't think that this is a situation where this is a public space, like a public park or a public parking lot. So that being said, it sounds like this was done on private property. I don't know if the association sponsored these parties. I don't know if the association provided the alcohol. If you did, there may be some liability if you didn't have proper liquor permit for the day of the party. So there's some other issues there that kind of concern me that you definitely would need to look into if you're going to have a party again at your clubhouse and provide alcohol. We would have liability if shopkeepers or dram liability if somebody got in their car and drove and were drunk and did damage to another person or property. So those are some considerations. A lot of associations have BYOB things, and that you may want to talk with your insurance agent to see how that might affect your policy and if you need to have an additional policy for those type of days. But I hope that answers your question. Okay, question 35 from a board member. Under ARS 103824H, special assessments, unless specified in the governing documents, are to be decided by owner vote. The governing documents might provide that board votes decides. Are there reasons in favor of placing assessments in the hands of one or the other board versus owners? Okay, so you're just relying on the Nonprofit Corporation Act for the statutory authority that you're citing here. Remember that as a planned community or condominium in Arizona, you first should be looking to your association documents and condominium law, the Condominium Act and Planned Communities Act, if you're a planned community, for guidance. So, really that would be the first place I would look. And I really have never, ever looked to the Nonprofit Corporation Act on special assessments because usually this is something that's decided in the association's documents and would not be something that would be controlling versus the Nonprofit Corporation Act, which we only use as a gap filler if there is no other reference to something and we're looking for an answer, let's say there's no quorum requirement in your documents, then we would look to what the quorum requirement is in the Nonprofit Corporation Act because Planned Communities Act and the Condo Act don't have a quorum requirement in it. Okay, next question, number 36. In the event our management company merges with another management company, must the board approve or is the current contract automatically transferred to the new merged company? Really good question. This has come up a couple of times today now, right? We talked about our industries changing and a lot of management companies are being bought out by companies from Texas, California, Florida, New York. And so does the board have the right to say no, or do we have to approve it? It really depends on what the contract says. So if the contract with your management company says that they can assign it to a third party, then likely you, without your approval, likely won't be able to have any say in that transaction. So you have to look specifically at the contracts. Sometimes the contract also may say that the contracts between like ABC Association and CD and E Management Company and its successors, assigns, et cetera. And if that's the case, they may be able to do that without your permission as well. One thing that you might want to do, being proactive, anybody who's listening in on this today, looks like we've got a really good turnout of people, 97 live right now, would be if you're negotiating a new contract, make sure you put that provision in there so that you're protected, knowing that this is becoming very common in our industry right now. Okay, next question, number 37. A homeowner has submitted an architectural request to install solar panels on the flat roof of his condo. My other board members are inclined to vote no because they feel that it has potential damage to the roof and will void the warranty on the roofing company that we have. I understand from the law that the HOA cannot prohibit the installation of solar panels, but it can restrict their placement. Can the other board members legally deny the request to install solar panels if it has potential to void the warranty on the roofs? The board president is saying that because the roofs are common elements and not owned by one person, homeowner does not have a right to modify a common element this way. Is that accurate? So generally speaking, yes. The homeowner doesn't own the property that they want to put the solar panels on. So I'm in agreement with your president on that. That being said, there is a state law that says that associations, or state laws that say associations cannot effectively prohibit the use of solar energy devices. And there's a case, the Garden Lakes case, a case that went up to the Supreme Court of Arizona that also addresses this issue. We have a great cheat sheet on solar energy devices that I would encourage you to take a look at. You can find it at mulcahylawfirm.com. And I think it's just called Solar Energy Devices, I think that's what the name of it is. I think our office can probably share it with you before this presentation is over today as well. But be careful. If you're a planned community and an owner wants to have a solar energy device, you most likely will have to approve it. If you don't want to approve it, you want to talk to your legal counsel and make sure you're on solid ground because 99% of the time you do have to approve those. Okay, next question is question 38. In regards to violations, is the board or management company required to send a letter stating the appeal was denied and include reasons? Or is an email just saying denied enough? Well, it would be best if you put a little bit more detail about why it's denied, but they really legally are not required to. Question 39. How to get other board members engaged and understand the importance of participation and not just leaving decisions up to the management company. Well, again, I'm going to push the boot camp because if we come in and do a boot camp for your board, we explain to them their fiduciary responsibilities and the fact that they have liability if they aren't doing their job and they can be sued, if they are not, being an active participant as a board member. And that's their job. That's their fiduciary responsibility to the corporation. If they don't want to do that, then maybe they shouldn't serve on the board. So I think the best way to do it would be to make them familiar with their responsibilities, maybe give them our cheat sheet on board member roles and responsibilities. We talk about fiduciary duty in that. Have a boot camp, have our firm come out, do a boot camp for your board. It's only an hour. We do it by Zoom. And I can talk through how serious these issues are and how they need to not be delegating everything to the management company and they need to have oversight of the management company. And hopefully that will get the message to them. Question number 40. What is a good rule of thumb for discretionary spending by a board without member input? 5%? 3%? I really don't know the answer to that question because I, don't know what you mean by discretionary spending. I mean, I'm assuming that you're thinking, if we spend $100,000 to replace the gazebo at the pool, is that something we should be asking the membership for approval on? It really depends on what your documents say. If your documents have a limitation on this and say any expenditure by the board over $5,000 or over $10,000 or over $100,000 need approval of the membership, then you are legally required to do that. If it doesn't say something like that, you may not have any legal requirement to ask for their permission if it's 3% or 5% or whatever. So you really need to look at your documents to determine whether there's spending limitations in there. Now, as board, you may want to go to the membership on really large expenditures, even if you have the authority to do it, just to make sure that they're in favor of it. You could discuss it at an annual meeting or you could do an informal poll. Those are different options as well. Okay, next question, number 41 from a homeowner. The HOA I live in does not send out the letters to vote on the street parking until 7 days before the scheduled meeting to provide the results. Most homeowners didn't receive their letters until the day before, and it was too late to vote. Our community calendar said that the HOA was going to hold a meeting in May to discuss the voting, and it was never done. Can the community do another vote on this, or is it one and done? So I'm assuming that you're talking about the new law the law that went into effect a couple of years ago, but that had like a date certain of June 30th to get this vote by. If you were a planned community and your streets are dedicated to the public and you wanted to maintain the ability to enforce your CC&Rs on those streets, you had to take a vote and have it passed by June 30th. It looks like maybe your association didn't get that vote in time. And yes, that time period has expired. You won't be able to do that. Okay, next question, number 42. Would you please clarify payment under protest? Is this a documented protest? Does this protest include common area lack of maintenance? I'm laughing because the minute I said this in this presentation, I was like, I probably shouldn't have said that because it's not anything formal. It's just wording. Okay, so if you're unhappy about how things are going, you should always pay your assessments, because if you try to say, I'm withholding payment of my assessments because I don't like how the trees are being trimmed or whatever, you don't have a good legal stand on that. We can still put a lien on your property. That is not a good legal defense. Now, when I said pay under protest, I mean, what I'm saying is continue paying your assessments if you're unhappy with something at your association. What I would recommend you do is send a letter saying, hey, I'm still paying my assessments. I guess you could say under protest, but I want you to know that I'm very unhappy about these things in the association. But whatever you do, don't stop paying your assessments because you're unhappy about something, because that will come back and to bite you in a bad way. Question number 43. We have only 4 more questions. Our architectural committee, per the CC&Rs, is totally separate from the board, but works with the board. At our AC meetings, we review violations we have noted, and if first notice or fines and fine amounts will be sent out. When discussing individual homeowner violations, can these be discussed in open meeting or in the case of a fine assessment in the executive session material? We keep meeting notes as to what was discussed, so need to know if open meeting or executive session is involved. Okay, so you have a separate ACC from your board, which is pretty normal. And at the ACC meetings, you talk about the violations that you see. And apparently you're sending out these fine notices. That's kind of unusual. Usually the board has enforcement authority, not the ACC. And so you're wondering, when you're discussing them as an architectural committee, should we do this in the open meeting or in an executive session? I really think you probably need to get advice from your attorney or our firm on this, because it's pretty unusual that the architectural committee is handling the violations. Usually the architectural committee handles the review of the applications, and then the board handles the violations. And typically that is done in executive session. Maybe you have provision in your documents that allows you as the architectural committee to send out violation notices and fines. It would be very unusual. If that's the case, you really don't have like closed meetings, but I suppose you could. It just is a very unusual circumstance. Maybe the way around it is just to use, like, instead of referring to names, you could say item number B on the agenda, we're going to move forward with a fine, instead of having to go into executive session. Okay, question 44, last 3 questions from the vice president of an association. Our property management company allows our board to do unanimous written consent to make some board decisions outside open or special meetings. Is this illegal or only ethically questionable? So my opinion is that you should not be doing this, that the open meeting law is very clear, that all decisions of the board should be made during an open board meeting or during an executive session board meeting that's properly noticed. And there are 2 administrative law cases in Arizona that say that these actions by written consent, even if it's allowable in your documents, are not consistent with the open meeting law. Also, the action by written consent or action without a meeting or action by unanimous written consent that might be in the Nonprofit Corporation Act, it is inconsistent with the Arizona open meeting law. So our firm does not ever recommend that boards be making decisions by unanimous written consent because we feel that it is not consistent with the 2 administrative law decisions that have been cited in this matter, not consistent with the open meeting law. And so as a board, I think lots of times management companies will just do this because it's easier to get things done. Just recognize if you are doing things like this, you really need to reapprove decision at a regular board meeting. And I really don't advise that you do this. Now, emergencies are different. If it's a true emergency, you have the right to make a decision any way possible just to handle the emergency quickly. But you should take meeting minutes if you are doing an emergency decision pursuant to the law that governs emergency meetings. And then at the next regular board meeting, you would read into the record what the emergency was and what was decided and attach those meeting minutes to the meeting minutes for that open meeting. Okay, we have a couple of questions have been added, so a few more questions. Question number 45. The Condo Act says that we have to have 1 meeting a year, the annual meeting. Our bylaws state that we are supposed to have monthly board meetings. Because ARS supersedes governing documents, are we only required to have 1 meeting, and can we ignore the bylaws that state a meeting every month? No, there's a difference here. So the annual meeting is your meeting of the membership where you elect directors, get like a state of the union of the association by the president, the management company, the treasurer. That's the meeting of the membership, and that needs to be noticed and handled once a year. Regular board meetings are where we handle the day-to-day affairs of the association. And if your bylaws say that you have to have monthly regular board meetings, you need to have those regular monthly board meetings. If you don't want to do that, then amend your bylaws to take that provision out. Okay, next question, number 46. How can a board have discussion regarding a recent reserve study that was completed before sharing the study with the community so we understand it well and can speak to it with the community? Anytime we have more than half of our board present, it constitutes a quorum. As an open meeting, this could be an hours-long meeting. Okay, so it sounds like your association just got a reserve study done for your community, which is amazing. We have a great cheat sheet on this if you want more information on reserve studies, what they are, how you can use them to benefit your association, requirements under Arizona law to disclose to potential buyers, reserve studies, etc. Okay, so it's perfectly normal for a board to hire a reserve company, get the reserve study back, and talk about it at an open board meeting. You are under no requirement to send that out to the homeowners so that they can comment better on it. If the homeowners want to receive a copy of it, once they become aware that it's something that we've had done, they certainly can request a copy of it and then ask questions or give their feedback on it at an open board meeting during the open homeowner forum anytime in the future. Let's see if I answered all your questions in there. Question number 47, which is our last question this morning. Can an HOA board deny removing violation fines if the violations have been corrected because the homeowner is past due on assessments? Okay, so this is from a board member. So you've issued fines on a violation, but the owner's corrected it. Typically, in that case, the board, they have the right to keep the fines on there or not, or waive the fines. Okay, just, by state law, we can fine an owner for a violation as long as we follow the procedure. Notice of the violation, opportunity to be heard, and then the board makes a decision whether the fine is going to stand or be waived. So the board has the right to waive or not waive it. Now, if they've corrected the fine issue and they're remorseful, usually the fine is waived. Sometimes we consider extenuating factors like this is the 10th time they've done it, and we waived the fines 9 other times. And if we waive it now, they're going to do it again. So you may not waive it. Maybe this owner hasn't paid assessments in a number of years. And like in this case, the board is factoring that in. I'm not saying that that's related, but sometimes decisions are made that way. You have the right to fine. I wouldn't base it on the fact that they owe past due assessments. I wouldn't have the minutes say that. I would have the minutes state that the fine stands because there was a violation. But being vindictive and saying we're not going to waive the fine because you owe us money on the assessments, I would not do that. I think saying that is not a good idea. Okay, that's it for today. We got through a lot of questions in an hour and 17 minutes. So want to give you a couple updates on a few classes that we have coming up. Our August 2025 HOA Condo Academy class is coming up here soon on Tuesday, August 19th on Zoom. And we're going to be talking about mastering HOA and condo finances. So I hope you'll join us for that class. Specifically, we're going to do a financial overview of important topics for your association, like creating your 2000 budget, which you probably need to be working on in August and September and October. We're going to talk a little bit about financial statements, what the treasurer's role is, board member financial responsibilities, what you need to be doing when you get that packet of the board packet, what specifically you should be looking for when you're looking at that board packet to make sure you're living up to your fiduciary responsibilities. We're going to talk about reserve studies, how to understand them, and reserve accounts. So it's going to be a great presentation on August 19th from 11 to 12 a.m. on Zoom about really all things financial about an association. So also wanted to let you know that we're going to also be having our next live virtual First Friday event, and that will take place on Friday, September 5th. So thanks again for being here today. We appreciate you caring about your communities and wanting to make them better and wanting to learn more about HOAs and condominium law. Have a great month of August. Stay cool, and we look forward to seeing you again soon. Take care, everybody.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review.